हॅलो, गुड मॉर्निंग एव्हरीवन.
Hey there.
सॉरी, आज थोडा झूम मध्ये इश्यू होता, सो आय कुड नॉट लॉग इन ऑन टाइम.
नहीं क्या हरकत नहीं क्या हरकत.
Good morning. Good morning from Mumbai.
Hi, good morning, good evening.
आणि मुंबईमधले सगळे लोक टाटा मुंबई मॅरेथॉन रन करायला गेले आहे. त्यामुळे जे अवेलेबल आहे ते अवेलेबल आहे तिथे. It's a good time over here. Everybody is running marathon in Mumbai at least.
Yeah, it's very popular event. Yeah. Many of my friends are running there too. Okay, so I think we are 4 minutes out. Let's get started. Do we have all the companies here on the call? Maybe we can check in the chat box.
Yeah, we can get started, and they'll update the attendance anyway. So
Okay, so
yeah.
today we are going to talk about IP. I'll just start with that. This is my own presentation. Just as a matter of curiosity, how many companies do have some patents? Just post it in the chat. I'll check it later on. Can you guys see my screen?
Yes.
Okay, so just a quick introduction and my background. I'm founder of a company here in Silicon Valley. My academic background, COEP, IIT Delhi, IIT Mumbai, and then Stanford University here. I have been a president in the past of a company called Memsig, CTO of another company, MCube, startup company, which went IPO later on. Few other startup companies, Econos went IPO as well. I have spent 23 years in startups with 2 IPOs, 3 exits with acquisitions as well. And over these number of companies, I have shipped more than 1.5 billion product units, different applications, different segments. I have 74 US patents total patents filed, 45 of which are granted so far, both US and foreign. Advisor to startup companies, advisor to UC Santa Barbara as well here, and board member of Marti Global. So that's just my background, and that's one of the reasons that I wanted to sort of talk about IP. My own journey in the world of IP is really from my own patents. As I mentioned, I'm founder of a company, so I'm filing patents for my company as well. But I have been CTO of 2 US semiconductor companies, was heading the whole IP development as well as the engineering development there. And that's where my experience in IP comes from. I'm not an IP attorney, so I just want to give that disclaimer upfront. So all the information that I'm sharing today is really coming from what I have learned over years, and I wanted to share that with you. So with that, let's dive down. First, what's the definition of IP? Then we'll go into the importance of IP for startup companies and how do we create that and how do we go about that. So IP definition, it's the creation of mind, inventions, literary, artistic works. So it's not just limited to technical side. It covers a lot of other things. But what we are going to discuss today is about industrial property. All of you are founders, entrepreneurs. So we are going to talk about industrial property. That does include patents. But IP is not just patents. It's more than patents. It's trademarks, it's industrial designs, geographical designs, it's technical know-how, trade secrets, and so on. So when we talk about IP, we actually mean all of that. Generically, people always equate IP to patents, and patents are one of the most important ones out of that. But we'll talk about these other forms of IP as well and the importance of that. In addition to that, copyrights are also IP. That includes literary works. For the discussion here with the companies, copyrights would include, for example, your presentations, anything that you share publicly. For example, here on the slides, I have put copyright there. And the idea being that if you create something, people should not just be reusing it without mentioning your name. or contacting you and asking for your permission. So that's what the copyrights are for. In some cases, they might charge you for using that material. In some other cases, it might be just as simple as asking for permission. So that's just a high level in terms of IP. Now, why is that IP important for startups? So all
Sanjay,
of you, yeah,
just one thing. Can you maximize this? Somebody commented on the chat.
yes, that's a good idea.
Thank you. I'll put it in a presentation mode. That may be okay.
If you scroll down all the way down, the last button, there is a there. Yes.
Can you see it now?
Yeah, we can. Yeah. Okay, good. We are good.
Okay, so the first thing that we need to file patents or IP is for a barrier to entry for copycats. Each one of us, all the founders, would be spending years into this industry, into this particular idea that you're working on. And it's quite possible in this world where there are lots of competition that somebody is going to just copy your idea, copy whatever you're doing. And then you have spent years on this and somebody would get there within months. So that's the reason that you want to file patents, so that you preserve what you have done, the rights to that, and also create barrier to entry for others. There are also other uses like licensing deals. In fact, later on, we'll talk about business models in some other session. And licensing is one of the business models where there are service sector companies, there are product companies, there are also companies which are product companies intended for licensing of their products. So that's you can only do that if you have a IP of your own, because without that, somebody is just going to replicate that effort or copy that. Royalty, again, depending on what your business model is, together with the licensing deals or without that, you can earn royalty as well. For valuation of the company, IP or having patents is very important. And some of you may have gone through this in terms of when you talk to investors. One of the questions that they're going to ask you is whether you hold any patents, because that's an indication that there are certain assets that you have which are very valuable assets in the industry. Cross licensing is also very important. There are lots of stories, anecdotes here, both in Silicon Valley, elsewhere in the world. On cross licensing, there is a story that goes here in Silicon Valley about T.J. Rogers, who was a founder and CEO of Cypress Semiconductors. And the story goes that some other company at that point, I wouldn't mention the name, wanted to kind of go against Cyprus at that point in terms of certain patents. And the story goes that TJ, he's called TJ here, he asked his secretary to print all the patents Cyprus held at that time. And they were in thousands. So it was a huge stack of all the papers. And today you might think of wastage of papers and so on. But this is the tactics. So when the meeting started, he had all these stacks of papers on his table, and that by itself was quite intimidating. When the meeting started, he just pointed to that and said, okay, now do you want to talk about patents? We have these many patents. And then obviously these kind of discussions then end up with cross licensing between the two companies instead of fighting with each other. So you of course have to have your own IP in order to get into that level. Selling of IP, of course, if the IP is valuable, you can also sell that IP. If you have a number of patents, you may decide to sell some, you may decide to license some. There is a value, monetary value to the patents. And there is an offensive value as well. You can go after competition. This happens all the time in the industry. As soon as some company is getting successful, somebody is going to sue or some other company is going to sue. And you can be in a position of offensive, being on the offensive side, if you own those patents. So that's the reason that this particular discussion on IP is very critical to all the companies, including startups, but particularly for startups, because without that, there is no survival for you. So this is a very common SWOT analysis that all of us do. And typically when we talk about SWOT analysis, we are focusing on the product SWOT. But SWOT analysis is also important from IP perspective. And for example, in each of these squares, and I wouldn't spend too much time on this, but you have to have some strengths in certain areas. These are product areas, but then IP area is also a strength. So you this is going to be exercise later on for you, is from IP perspective, look at what your strengths are. Look at where your weaknesses are. I can take some examples. For example, eCoop is a company which is doing in this particular cohort, which is working on water purification, certain bottle, and so on. So think of it, and again, I haven't checked with the company whether they have a IP on this or a granted patent on this. But in this case, if, for example, there is an IP with some other company, competition, or another player somewhere in the world who has similar IP, then that becomes your weakness if you don't have your own IP. And I'm just taking that as an example. I don't know. I haven't checked with them in terms of their IP. There are opportunities as well. We have had companies here, startup companies in our past cohorts, and I'll show you some examples that they're using the licensing deals with their IP. So that's the opportunity part of it. And the threats part of it is what we discussed in the previous slide, which is if you own IP, then or if you don't own IP, then that's a threat to you. If you own IP, then you can be on the offensive side. So whichever company you are, whichever sector you are, try to do this analysis about your own company, and we can discuss in the next week's breakout session in terms of where you stand on all these. If you already have some IP, then probably that's going to be more on the strength side. But if not, then there's a big risk. And then as we talk about de-risking in one of the later presentations, this is going to be a risk for your company, your startup company. And then you have to think about how to mitigate that risk by having your own IP. So some examples here. One example is one of my previous companies, Philips, owned IP on CDs, compact discs. And today we don't use compact disc anymore, but or the usage is minimal. But there have been times where there were 1 billion CDs being produced every year. And on each of these CDs, this company earned about 1 to 2 cents of a royalty. So you can imagine how much revenue was there, just hundreds of millions of revenue over years, just based on royalty of that IP. So that's how critical that is. Now you might say, okay, we are not in that particular space, or we don't have that kind of a solid IP. But startup companies like our cohorts also have licensing business models. And in one of our previous cohorts, there was a company by the name Go Vidyut Mobility. And Go Vidyut works in the electric vehicle space. And they have IP, they had a patent on this electrification or EV efficiency, using it for two-wheelers, three-wheelers, four-wheelers, and so on. And we again had this company in our cohort, and their focus eventually turned out to be on the licensing part of it. So even though it may not be comparable to the previous example in terms of billions of units, you can still imagine how many two-wheelers, three-wheelers are there on the road across the world. And then if this company succeeds in terms of getting their IP to be licensed to these manufacturers, that it's going to be a huge revenue for this company. So I'm just sharing some of those as examples. Now, what can be patented? So now that we talked about the importance of that, you start thinking about what can you do for your company? What can be patented? So here are a few things that can be patented, and later on I'm going to talk about what cannot be patented. So in the patentable subject matter, there is a process or method can be patented. Machine or circuitry can be patented. Manufactured articles can be patented. New compositions such as pharmaceuticals, for example, all the drugs that we use, they are all patents there. And you hear about that, right? All the drug companies talk about those. One of the most important criteria for patenting something is it needs to have novelty. It must differ from the knowledge that already exists, which is called prior art. And it must not be in the public space, must not be disclosed by the inventor for more than a year before the patent application. There is a utility requirement. So there is a class of patents which are called utility patents. And the requirement is that it must be useful. Uh, the exceptions to that is what is called as design patents. In design patents, you can patent a certain object with a particular shape and so on, but that's a different category. That's a design patent, as opposed to most of the patents that are of interest to us are related to the utility patents. And then non-obviousness from prior art is the most important criteria. So when you file any patents, and this is any patent office, whether it's the India Patent Office or US Patent or anywhere in the world, PCT and so on, they're going to assign it to examiners who are experts into that field. And the examiners will look at all the prior art, all the previous patents in that particular field. And they are looking for novelty. They are looking for non-obviousness. So if there is something similar to what you are claiming that you have invented, exists in the past or close to that, and then as a deduction from that or as a minor tweak from that, if what you are claiming can be derived, then the examiner is going to reject your patent because he or she is going to say this is obvious from the previous art. So for those of you who have gone through this process, you are used to it, that the examiners will check every line and every patent and so on. And most of the time the claims get rejected because they say, okay, look at this patent XYZ some years ago. And because that one said this, and there's another this YZ patent, which said another Y thing, that you combine X and Y, and that deduces to what you are doing right now. So because of that, we cannot grant you a patent. So that's the obviousness criteria. So that it could be a combination of number of different patents from number of different players. And if an examiner thinks that it's obvious because of those several patents that this leads to what you're working on, they could deny your patent claims. So when you file patents, this is something that you have to pay attention to, or your patent attorney has to pay attention to that, to say you have to show the differentiation with respect to the prior art. Now, what cannot be patented is you cannot just patent an idea. So many of you, of course, have, because you have a startup company, there is certain idea, but just as idea, you cannot patent it. It has to be embedded into something. For example, even if I mean, just the common example that is given to that is, you cannot say, okay, I have a space vehicle that will go from Earth to Moon. You cannot just say that, now I'm going to patent that. You will have to be very specific in terms of saying, this is how that space vehicle needs to be designed. And this is how it needs to develop this particular force that it is ejected from Earth and goes into the outer space. So those details have to be there in order to apply for a patent. Similarly, the things that cannot be patented are also mathematical formulae cannot be patented. Naturally occurring substances cannot be patented. Laws of nature cannot be patented. A process done with human body cannot be patented. So a combination of that though, for example, if you come up with a pharmaceutical combination of something, then that becomes a method or a process, and that is patentable. Now, if you have an idea and you say, okay, now this is worthwhile and I'm going to patent it, then the question that comes next is, where should you patent it? you have a number of choices. If you are a company which started in India, for example, you may decide to patent it in Indian patent office first. Here in US, for example, you may decide to patent on USPTO first. So there is that first level of protection that you're trying to get. But then the question is, where do you want to protect it? Where is your competition coming from? That's what you have to think about. That if you believe that in the area that you're working on, there is a competitor from certain country, then you have to file in that particular country in order to be most defensive as well as offensive to that particular idea in terms of its protection. Cost of patenting in those territories is also important. So I'll talk later on about how many different ways of patenting are there, how the patent treaties work and so on. But if you have to really protect idea all over the world, you end up filing multiple different versions in the sense of there is a, for example, for us, it's a US patent first. And then there is something called PCT, which there are member countries, and that gives you certain protection into those areas, those countries. And then in addition to that, you might do a country filing. So even if you do PCT, you might decide to file in a specific geography. Like in Europe, you might say, okay, yeah, I have a company, similar company potentially coming from Germany, let's say. Then you might file on German patent office as well. And then some countries are not part of these treaties. So if you want to have coverage in those countries as well, then you have to specifically file in those countries. So that becomes a kind of very expensive scenario. But companies which have, first of all, if you have a need to protect in all those geographies, then you will end up doing that. I have done it in my past life in terms of patenting it in China patent office, and then Taiwan, and then PCTs, and then Europe, US, and so on. So for one or two very core patents, you may want to consider that if you believe that's something that's going to be applicable all over the world. We do that, for example, when we were operating in smartphone space, for example. So smartphones are manufactured all over the world. So if you are patenting something related to that, then you may want to protect it all over the world. Whereas if there are ideas very specific to a particular geography, then you may just patent in that particular geography. There is also a question of ability to protect in those territories. And what I mean by that is, I wouldn't take a name of specific country, but sometimes geopolitically, geographically, it's very hard to protect patent in certain countries. So you have to be careful in terms of where you file and how you file it. So at the end of the day, you might still file it there, but you have to write it up kind of differently than what you would have written it for some other countries. This constraint in terms of how you write a patent also depends on the cost of patenting, because sometimes you have to do translation into those languages in those countries, and then having a 20-page 25 claim patent in those many countries becomes very, very expensive. So let's talk about international patent treaties and laws. The patent treaties and laws are intended so that if you have protection in certain country, it's applicable to similar protections in other countries. So that's why these patent treaties are there. But the patent laws and processes do differ from country to country. So it's best to hire experts from those specific countries where you want to file. Now, this Paris Convention Treaty, which came along quite many years ago, there are 176 member countries, and they guarantee the same rights to foreign inventors as their own citizens. So which means there is no discrimination. If you are competing with somebody in that country, then you get the same rights if you have filed it ahead of the competitor. It preserves the original filing date as long as the patent is filed in other country within certain duration. It's typically 12 months. So you file it in your home country, And then for example, if you are from India, you might file in Indian patent office. And then within 12 months, you file it in other territories. And you get the same rights, then it preserves the same filing date and so on for you. I spoke about Patent Corporation Treaty or PCT. There are 148 members. So once you file a patent application in a particular country, then if you want to extend it to these other geographies, which are members of this PCT treaty, then you can file one patent, PCT patent, and that would give you some level of a protection. And if you want some additional level of protection, then you have to file into member countries, specifically into a country of interest to you. Okay, so milestones in patent process. And one of the reasons I want to spend a little bit time on that is I do see a lot of confusion among entrepreneurs about patents, about the status of their patents as well. And I'll give you a certain example. This is a one cohort before this cohort. So we had one of the cohort companies, startup companies, when they applied to us and when later on we were having discussions, this particular founder claimed that I have a patent. That's how he put it. He said, I have a patent. And I said, okay, where is your patent? What's the number and so on? And it turned out after a lot of digging that he was confusing a provisional patent application with having a granted patent. And you will see in the steps here that there is a huge difference between just filing a provisional patent to having a granted patent. So with a provisional patent, okay, you can still claim that you have filed a patent, but that's not same as saying I have a patent or I have a granted patent. So there is a difference in that. So what are these differences? First is called provisional patent. What that means is, and when do you do that, is if you have an idea which is not thoroughly exercised or thoroughly vetted out, and you need some time for that. For example, if you are into a certain design, let's say we are into these electrical designs and so on, circuit designs, and you have an idea, but you need to still run these simulations, you need to do a chip development, and you have to evaluate that to make sure that it works. Then in such cases, you file a provisional patent first. What that does, it is preserves the date of filing, the date of invention into this world of IP, saying that, okay, on this such and such date, this idea was first applied. And then you have 12 months to convert it into what's called as a non-provisional patent. And that becomes a final patent application. It's still not a patent, but it's a final application. With a provisional patent application, it's not, they don't start examining that application. It's just there. It just gives you credit for the filing date. Other than that, nothing happens. It just sits there in the patent office. And only after you file non-provisional patent, or you convert that provisional to non-provisional, that's where patent office will take it seriously. They would start assigning it to the patent examiner. And that from that time, then it might take 2 to 5 years to get that patent examined. So just having provisional doesn't take, okay, other than giving you a kind of priority date, you don't get any processing, patent processing on that one. You have to do that conversion to non-provisional patent. And then after that, once you file non-provisional, that's where any patent office will assign it to patent examiners that that particular patent office has. And then comes the next step, which is called office action, which means the patent examiner is going to come back to you with his or her comments saying, okay, you have such and such claim, but this claim is either approved or denied for such and such reasons. And more often than not, the claims are denied So you have to go back and convince the examiner that no, for this reason you believe that the claim is valid claim and you should get that claim. You are very lucky if a patent office right away on first time says, okay, we agree with all your claims and here goes your uh, patent grant. So that's the office action. And the office action loop can be quite iterative. Sometimes it goes into several circles, back and forth with the patent examiner. You need to have very good patent attorney, patent law firm in order to do this action about or the response on the office action. Because this is highly technical and it you have to be in a position to convince the patent examiner that you have looked at all the prior art, all the cases, all the comments from examiner, and after that, why you believe that that's still allowable patent. And then after all this work, which typically could take 2 to 5 years. This is on US Patent Office. The speed of office actions or the patent approval process varies from country to country. So in India, this duration could be shorter or longer, and you cannot do much about that. It really depends on the patent office in terms of how many resources they have as examiners and others. So your best course is that you file as early as possible, file a non-provisional, and then you get that at least in the process of examination and so on. And then you can expect that it will still take 2 to 5 years for the patent to be granted or office action. Once you have a patent granted, you can, or once you have done the non-provisional filing, you can also decide to do foreign filings, which we talked about previously, that first you file it in your home country. For example, I'm filing first in US Patent Office, and then within certain duration, I can file it in PCT, usually 12 months, and then into other countries, whichever countries are of interest to me. So after all these processes, the foreign offices, by the way, also take the same 2 to 5 years, and then, or some could be faster. And then after that, the patents are granted. And then after that, also you have to maintain those patents, which means you have to pay fees to the patent office. These are called annuities, and the annuities are in steps of number of years. So first 3 years you pay certain fees, 5 years, 10 years, and so on. So that's the process of patenting, and that's the different milestones in this one. Validity of patent is usually 20 years from the date application was filed, and subject to maintenance fee. We talked about annuities in the previous one. So there could be kind of different steps in terms of those maintenance fees. There is one for first 3.5 years, then 7.5 years. So that's when you get another bill for it. If you pay for it, then only the patent office maintains it, because the patent office says, okay, I also need to spare some costs to maintain your patent. So only if you keep paying this, then the patent is maintained. If not, the patent would be abandoned, and then at that point it's open for others to copy it. After the patent has expired, then anybody can use patent without permission of the patentee, provided the matter is not covered by other patents. So that last clause there, not covered by other patent, that's important, because many times as inventors, what we do is you file a patent and you know it's going to expire 20 years from then. So in between you file something which is called continuation patents, continuation in part or continuation in patent. And if you keep on filing that, then for the continuation patent, let's say if it is after 5 years or 2 years or 3 years, then you get additional 3 years after that 20 years, because this CIP patent then kicks in, and you get sort of extension on the original patents based on that one. So what prevents, now that we have gone through this, okay, hopefully there is some awareness in terms of that, but typically many people don't file patents, many companies don't file patents. And if you look at the statistics of the number of patents filed, India is way far behind in terms of that statistics. And a lot of that has to do with the lack of awareness why patents are important. If you think about the highest number of patents being filed, those are the top three economies in the world. That's US, China, and Japan. Those have the largest number of patents. And it's again because of the awareness was there for many, many decades. And these countries have been obviously in the forefront in terms of new developments, new innovations, and so on. So as a combination of both of that, awareness as well as the product development, that these three countries have been in the top three worldwide in patents. But I can see now I'm seeing that the awareness is growing in India as well, and government has been giving a lot of incentives, both state and central government. So with that, that awareness is there, and of course, I have given in the past webinars as well on this IP protection and patents and so on. The idea was to create that awareness because it's a good thing for all of you as entrepreneurs to have these patents or IP protected for your company for the benefit of your future. Sometimes it's not a priority in the company. You first focus on development, and then at some point you say, okay, what about patents? And then suddenly you wake up and start doing that. But the sooner you start getting into that, the better it is, because as we discussed in the past, it's going to take you 2 to 5 years to get a patent granted. So if you start 3, 4 years later, then it's that much delayed time frame for getting a granted patent. Cost of this patent filing is also huge. It's not small, and that has been one of the big deterrents in terms of filing patents. And this is the reality. So now Indian government is now incentivizing that both for filing domestic, meaning Indian patents, as well as US patent or foreign patents. So there are different government schemes in order to subsidize or pay back the cost of patent filing. So you should look into that. I'll just touch on that, and later on, I think we will discuss what those schemes are. Don't know how to patent. That's also a big cause for not having the patents. So that's the reason that we have this one. As much as the rest of the presentations we have gone through, which is customer development or business development and business canvas and so on, as much of that is a foundation for your company. Patents are also foundation of your company. So IP is a foundation of your company. And that's why it's critical to have that foundation covered. If your foundation is weak on that, you might do the rest of the things and you may still lose, because at some point you do all this development, all this work, try to get revenue. And at that point, if somebody comes there and says, okay, here is my patent and I'm suing you, then the whole company is gone. And that happens for real. It happens here in US quite a bit too, that people wait, big companies wait until the startup company has been successful to a certain extent in terms of earning revenue on certain product. And then the big companies jump in and then they file a patent lawsuit. So just having your own protection there is very, very critical if you are serious about particular IP. Resources of our patents, as we discussed, we need to have a good patent attorney, good patent law firm, and these resources and certain patent office requirements as well. Those are important in order to get moving in terms of patents or get patents granted. Lack of novelty, as we discussed, novelty is important for granting any or getting a patent granted. So lack of novelty is a big problem if you, in terms of getting that patent. And as I kind of gave some examples in the past, a previous discussion, patent office, patent examiners will examine thoroughly whether your ideas indeed are novel or not. So they would check all the prior art to see whether that was kind of an easy continuation from some of the past work or prior art. So when you think about patenting, you have to also first convince yourself and hopefully your co-workers and others in terms of that novelty of what you're trying to patent. If not, you would spend all these resources and costs, and the patent office will later on tell you that there is no novelty on that. So you have to do some homework before you file for it. So when do you know when it's worthwhile to patent? Now we have spoken about these, there is awareness and all that. So then the question is, what's really worthwhile to patent? So I'll give you some examples. If your company relies on a core idea, and I'll give you some examples from this cohort. For example, eCoopy is one of those, which relies on this water filtration, certain bottle and so on. That's the core idea. That's their product, right? So if this is their life in terms of survival, they better have IP on this. And if they plan to sell this worldwide into other geographies, they better cover themselves in terms of having a patent in that territory as well. There are other examples. I gave example of Go Vidyut, which was from the previous cohort, into EV space, electric vehicle space. Core idea, right? They wanted to license that. So of course, the first step is to have a patent, and they did have that one. Another company in this cohort is RxZoom. So that one is into medical space and competing again globally. So in that case, that's the core idea. That's their core product. So they have to have patents into that particular area to ensure that, first of all, they are not encroaching on somebody else's work, or somebody else doesn't claim later on, once they are successful in getting revenue, that this is their IP, or this is extension of their IP. And again, that happens all the time. The big companies wait until you create a market, and then after that, they'll come after you, because by that time they would have a stack of patents. They have been in business for a long time, and then they uh, file lawsuit, first to just scare you that uh, your existence could be gone just based on their lawsuits. Indeed, if they win, but also to fight that lawsuit itself takes a lot of resources. Patent attorneys cost a lot and all that. So it's in your interest that defensively as well, you hold certain IP. That way, if somebody threatens you, somebody files a lawsuit, you say, look, this is my IP here, which is, let's say, hopefully granted patent. And then at that point, you can decide to cross-license it, or they can settle the lawsuit, and they could just pull back. And I'm not giving fictitious examples. This happens all the time in the industry. I mean, that's the reason many of our companies in the past had in-house legal counsel, in-house patent attorneys, and so on. Because first of all, you have to patent your own ideas. But then when somebody threatens you or somebody files lawsuit, you need to be ready in order to fight that lawsuit. When you're solving a difficult problem, that can get you competitive edge. So even if it's not a core idea, then you understand that in development of these products, there are certain challenges, which all of us have challenges, right? When we are solving difficult problems, that if you can give you a competitive edge, put you, let's say, year, 2 years ahead of competition, that's something that you need to file. Many companies, and my companies in the past had patent committees. So it's not just one person's decision, that we usually have a number of people that we get together, and we use certain criteria in order to decide what needs to be filed and not. Because again, as startup company, your money is also limited, and these patent filings do cost a lot, especially if you are filing in US or other territories. So there is always that cost versus benefit ROI calculation on these patents, and you have to kind of take it case by case basis. Okay, so we talked a lot about patents, how they protect inventions and so on. But in addition to patents, there are other IPs, other forms of IPs. One of that is a trademark or service marks. We'll talk about that in the next slide. The other one is copyrights. And then there are trade secrets and know-how. And it's also important to differentiate these from patents and why you shouldn't do that. So trademarks and service marks, these are any word, slogan, symbol, design, or combination of these. And we are all used to it. I mean, you see advertisers all the time, and you see trademarks, particularly there. Coca-Cola, for example, advertises, Pepsi advertises, and you see that these words, the way they are written, Coca-Cola, Nike, and so on, they're written in a particular way, and there are trademarks based on that one that nobody else copies that. There are also service marks. So this is in the source of services rather than goods. In the first two examples there, these are the goods or products. Whereas FedEx is not a product, they're a service company, but they also have a service mark, which is that FedEx. It's written in a particular way. So that is service marked already. That the first three letters written in a particular way, the second, the fourth and fifth in a particular different color and so on. So if you again want to do that trademark or service mark for your own company, you can also think about that. Copyrights are original work of authorship. Copyrights are more common into the literary area, but for example, into your presentations and other things, that's copyright is applicable there. And you just put a symbol there, copyright symbol, and you can put your company's name there, just like I have done here for my own name. Okay, trade secret is another important thing. So we talk a lot about patents, but sometimes we don't file. Sometimes we intentionally don't file something and decide to keep that as a trade secret. And you may ask why. The reason is patents eventually, when they are granted, they get published. I mean, that's the purpose of it, that world needs to know what you have patented. That means they know exactly what you have done and how you have done that. Whereas trade secrets, on the other hand, you want to keep it as a secret. So in this case, you are not going to publish it, you are not going to announce it to the world as to how you are doing it. But they know that you have trade secret. So for example, I'll just give some examples. We all the time use, we are customers of Starbucks, for example. Starbucks brews the coffee in a particular way. That's their trade secret. So they have kept it, that recipe or formula, as a trade secret, and it's very highly maintained in terms of that secrecy of that one. So these are not filed. So you won't find a patent which says, okay, this is how Starbucks coffee is made, but it's their trade secret. And trade secrets also can be fought once you show that documentation in terms of how you are maintaining that. There are incentives from state and central government. If I get chance, I'll show you one or two of these later on. But if not, I'll just post it into our area so that you can go through that. These, of course, get updated from time to time. So the government incentives, Maharashtra government also gives incentives. Make use of that. Sometimes the incentives are in a way that they let you first spend your money and then they reimburse you for that or part of that. Or in some other cases, they may decide to kind of subsidize you or pay you right when you are doing that. It depends on which kind of incentive, whether it's a state, central government, and so on. So look at the schemes that are available. And for startups, again, conserving your money is important, but patents are also important. So you kind of balance that by getting some grant for just doing the patent filing. So in summary, filing and protecting intellectual property is very important. It's an important asset for the company and you get valued by that. For example, eventually we'll talk about your fundraising, right? And then we'll talk about what's the value of your company if it's a valuation round. And then at that point, whoever is the appraiser of the or valuer of your company is going to ask you this question as to what IP assets do you have? And that's going to be one of the way to value your company. So there is a monetary value to that. There is a value when you get funding, and it also means a lot for the venture capitalist or your angels and so on, your investor, in knowing that you have certain IP, for example, if you have a granted patent. And the reason for that is we all work in a very, very specialized areas. The investors are very savvy. Most of the time they know what's in that area, but they don't have time and resources to dig down into the details of, if you say, oh, I am really differentiated, nobody else has what I have, and so on, they don't have time to really verify that. But if you hold a patent and if you show them this is my granted patent, there is a first level of due diligence where they say, yeah, now this has been verified by at least a patent office. So now, rather than just taking your word for it, they know that this is indeed a novel idea and there is a basis for it in terms of that evidence of that patent. And you have to keep innovating to become a leader in this space. So based on all these discussion, we always give assignments to startup companies. So the assignment for you is to list all the core ideas of your startup company or product. And then you have to think about, are these patentable? So in the next week's discussion, breakout discussion, I want the companies to come up with this and just mention what these core ideas are and whether you have something patentable, which means it's innovative, it's differentiated, there is a novelty there in what you have done, and whether it's protectable. What are the barriers to entry for your competitors there? The existing competitors, the ones that are going to come up in the future, is there IP or prior art that is barrier to your core idea? So again, I gave some examples of the cohort companies in this cohort as well. You have to analyze that. If you jump into something and then later on somebody comes after you, then you could end up wasting the whole number of years and resources and money on it. And I can give a lot of examples on what happens in the startup area and so on, if we have time for that one. Identify threats from competition. We talk about SWOT analysis. You would have done it in the past, but do it specific to the IP threats. So we'll again discuss that for each of your scenarios. And then you have to also list out, in addition to patents, what other IP is core to your company. Copyrights, trademarks, trade secrets. In some areas, trade secrets could be important. Or know-how is also important. So know-how will also differentiates with respect to patents, that you don't file a know-how. It's considered something that's secret to you, that your own employees know that, and you guard it very carefully within your company as well. And you do that by having the employees sign non-disclosures and all those kind of things. So that's how you protect your know-how. Is the IP filed, and if not, why? So please spend time in sort of looking into that, thinking about that, because if you have not done this same level of thinking in the past, now is the time to start on that, and then come up with a roadmap to protect your IP. The whole idea behind this is to take you to this next step. And when you get to this eventual next step here in terms of the business pitch and getting to investors and so on, this whole effort, this one slide, or the work that's done with respect to this slide, is going to be of tremendous help to you. Even if you don't have a patent by that time, just doing this exercise, saying, okay, this is my core idea, and yes, I'm doing such and such thing in order to protect that. That by itself would be very reassuring to your investors. So unless you do this homework, you may not be in position to get there. So with that, I'm going to end this presentation and open it up for just a few questions, and then we'll go to breakout rooms. Any questions?
Yeah, there are questions on the chat.
Okay, let me go to that. How much is the difference that is accepted? Any percentage?
So I'll just Good morning, good evening, sir. I'll just add, a couple of things over there. So when you mention that, when you apply for a patent or IP, the scrutinizer kind of, checks that what is there relevant, which is already patented, and now the scrutinization will happen. So while acceptance or rejection, what is the percentage that they see that, okay, this is more than 25%, so, approve this. If it is less than 20%, okay, so this is not patentable. So is there any criteria, something like that, which from your experience that you can share?
So I don't know how to split that as percentage wise, but if you think that the idea is obvious based on the prior work, and all the prior art would include all the patterns that are maintained or in existence, which means those are within that 20-year bound and so on. So if it's obvious from based on any combination of the existing patterns, it doesn't matter whether it's 25% or 75%. If the examiner thinks that it is derivable based on the existing work, they would deny it. So it's a binary thing. They would just, it's also subjective to the examiner as well.
Okay, got it.
And what happens also is that, for example, if you file 20 claims, they may accept a claim or two and might deny some other claims. So in that sense, it's in your interest to write it in a way that you have some dependent, some independent claims that could get granted and some might get rejected.
Sure.
I think
Thank you.
Yeah.
I think what Sanjay ji said actually is very critical statement there. See what really there's a lot of stuff in the patent filing and application. What really is material is a claim section. You'll say claim XYZ. And my experience is that if any claim which is just completely non-defensible, the term really is called defensible. Defensible means that you read that and nobody can conclude that there is some prior pattern based on that or a natural order, right? That claim has to be defensible. If they find out that a claim is non-defensible, your chance of even doing anything, even if you come back and say out of these 10 claims, one is not to do, your lawyer will come back and say there's no value. If I remove that claim, there's no value to the patent, right? So you have to be very careful about those claims. And there are also two type of pattern. One is called defensive pattern. You're just trying to just avoiding somebody claiming that you didn't do it. It's a defensible pattern. And other is little more offensive pattern, where you claim that, hey, based on this pattern now, nobody can have a business model without paying me. So you also have to be very careful about two different differentiations in your patent filing.
Okay, good comments, Mandar. So I'll just go over quickly, only a few, because if we spend time on this, our breakout room will be delayed. So in terms of how do I know if patent for innovation or there is a prior art on that one? Either you can actually, most of the patent offices allow you to kind of look into the existing patents. So you can do prior art search by yourself too, but best to have a patent attorney, somebody who's specialized in that area, because they are aware of that and they have access to more resources than you have. Okay, so is India part of PCT? I'll check on that. Most likely, yes. India is part of PCT. But if you want to protect, particularly in any country, in addition to doing PCT, you also file in that particular territory. Some territories are better than others for patents. So usually, again, countries like US and most of the European countries have been good in terms of preserving the rights. But it all depends on your own product, whether you're selling into that country or not, or that territory or not. If not, you wouldn't file it there. If your product is just applicable to India, for example, just file it in India. And in terms of reinforcing that patent, again, you have to reinforce that. You have to make sure that patent office you work with that particular patent office to do that. Insight on some territory. Okay, so we covered that. Yeah, so I think with that we covered some of the questions. I may not have covered everything here, but we will. Yeah, and thanks for the companies who posted there in terms of their IP. So Sapphire X has it, as I expected that they would have it. C-Probe again is a company would have their patent. And our past cohort companies, many of them had patents also. So it's a good idea that rest of you start looking into that, and we'll discuss your specific scenarios. Service sector companies less likely to have need, but then also there is the barrier to entry also becomes lower, because if you don't hold something that's proprietary to you. So you have to always think about what could be barrier to entry for my competitor. Um, if because after all, once somebody is successful in certain area, then competition comes up in that area, no matter what you're doing. Okay, so with that, let's switch to breakout rooms, and then at the end of the breakout session, we'll come back to the main session, and if there are any common questions, we can also answer there. Dave, do you want to flash the breakout sessions?
Yeah, I'm just opening the breakout rooms now. Yeah, so all of you should see a pop-up saying join breakout rooms, so you can join your respective breakout rooms.